This is a video that YouTube does not want you to watch. It's also a video that I did not want to publish. For over a year, my team and I have been conducting an investigation into the theft of our videos by a YouTube channel owned and controlled by the Russian government. But as our investigation unfolded, we began to realize that what we had uncovered was so much bigger than anything we could have ever imagined. This is not a political video, nor is it a fictional one, although I wish it was. This is a true story, a story about YouTube's intentional efforts to undermine the United States of America in collusion with the Russian government. It's also a story about copyright infringement and YouTube's desire to provide a safe haven for copyright pirates. Now, before you click away, I know that copyright may not sound like the most exciting topic. I get that. But trust me when I tell you that it is an important one, especially if you create original content here on YouTube. As this video will prove, executives at YouTube are turning a blind eye to brazen, repeated, and obvious infringements of our channel's copyrighted videos in an effort to protect the Russian government's YouTube channels. To that end, this video will also prove that YouTube has acted and continues to act at the direction of the Kremlin, even if it means violating YouTube's own rules and policies in the process. As you will see in this video, a brazen copyright pirate has been stealing our videos for years. Upon learning about this about a year ago, I filed takedown notices with YouTube. The pirate received 3 copyright strikes and was subsequently terminated under YouTube's 3-strike policy. Now, had this pirate been your average channel, well, that would have been the end of the story. But unfortunately, the pirate in this story is not your average channel. It's the Russian government. Indeed, RT, also known as Russia Today, an entity that is owned and controlled by the Kremlin, has been stealing videos from our channel for years. The only reason that we never knew was because they've removed our watermark and then changed the saturation to avoid detection. But rather than apply its policies to Russia's channels, YouTube has decided to do otherwise. Immediately after RT was shut down, following 3 copyright strikes from our channel, the Kremlin offered YouTube an ultimatum: bring back RT immediately, or YouTube and Google would be banned from the Russian market. Less than 4 hours later, RT was back. Ever since caving to Russia's orders, YouTube has since launched an attack against our channel to destroy our copyrights. As exposed in this video, YouTube has taken the unbelievable position of not only defending a pirate's brazen theft of our videos, but in fact, YouTube is actually attacking the copyrights of our channel, and by extension, your channel. According to YouTube's lawyers, our videos are not copyrightable because they, quote, consist entirely of public domain images, end quote. YouTube's lawyers have even gone so far as to call our copyright claims against RT misbegotten and dubious at best. By the end of this video, I invite you to judge for yourself whether our claims are misbegotten and dubious. Now, if you're a longtime fan of our channel, then you already know that what YouTube's lawyers are arguing is simply not true. Of course, our videos are original. Our team spends thousands of hours creating stunning 3D parallax visuals which have become a signature hallmark of our brand around the world. Also worthy of note is that the content stolen from our channel is protected by our copyright registrations, which were granted by the US Copyright Office. What I believe is perhaps most disturbing about all of this is that if YouTube is successful in its arguments, then YouTube will be successful in destroying the copyright protections, not just for our channel, but potentially millions of other content creators. Of course, YouTube knows this. They just don't want you to know this. To understand why YouTube is attacking the YouTubers who make YouTube, well, YouTube, you have to understand the larger picture. YouTube is at war with America's copyright law. For over a decade, YouTube's parent company, Google, has been quietly paying millions of dollars to prominent legal scholars to echo support for anti-copyright legislation, or as Google would call it, progressive thinking. Google handsomely pays its network of influential legal minds to preach its anti-copyright agenda to judges, politicians, and university students, all for the express purpose of trying to move public opinion towards what Google believes America's copyright law should look like. As exposed by the Wall Street Journal in 2017, Google has a wish list of policy-related topics, a secret menu, if you will, which it provides to respected legal professors. In exchange for publishing academic research on America's laws concerning antitrust, copyright, privacy, and other topics that directly affect Google, Google provides these academics with research awards ranging from $5,000 to $400,000. When you read these Google-funded papers, you will find an unsurprising theme. They all promote legal opinions that support Google's business model, weaker copyright protection, watered-down privacy laws, and more regulation, presumably to make it harder for new startup incumbents to compete with Google. As Forbes put it, it is a secret academic influence peddling effort by Google to shape government policy to suit its business needs. And the most insidious part, while this may be legal, there's rarely disclosure. One study found that more than half of all Google-funded academic research concerning topics that directly affect Google conveniently forgot to mention that the research was funded by Google. And it's not just academia. Google also funds a number of cleverly named nonprofits with harmless-sounding names like the Center for Democracy and Technology, Public Knowledge, and even the venerable EFF. Over the past year of conducting our investigation, I found it remarkable how these charities oftentimes appear before courts in important cases that Google is not actually party to, but would be affected by. These organizations try to masquerade as independent third parties, but they're not independent. They are in fact funded with millions of dollars from Google, oftentimes run by former Google lawyers, and make legal arguments that benefit, you guessed it, Google. If you're still confused as to why YouTube lobbies for anti-copyright policies that hurt its own alleged community, it's because, surprise, it helps YouTube make more money. See, here's the dirty truth that everyone at YouTube knows, but no one dares to talk about. YouTube profits from copyright infringement, and it profits significantly. This is an open secret. You don't have to look hard on YouTube to find bootlegged movies, entire episodes of TV shows like Family Guy with tens of billions of views, and other obviously pirated content. Why does YouTube turn a blind eye? Simple. Because pirated content is not viewed as a liability at YouTube, it's viewed as an asset. In fact, copyright infringement is the foundation of YouTube's entire business, and that is by design. See, contrary to what YouTube says publicly, YouTube does not care about copyright infringement. What YouTube cares about is its perception about caring about copyright infringement. This is not my theory, it's almost a verbatim quote from YouTube's own co-founder, which was exposed in the infamous Vimeo lawsuit a few years back. By my calculations, YouTube profits several billion dollars every year from pirated content uploaded to the site, and that is on the conservative side. Ladies and gentlemen, let there be no doubt. YouTube knowingly profits from copyright infringement, and it is in fact precisely this reason for why YouTube is lobbying to convince the legislators to enact new laws that would make it harder for legitimate rights holders, people like you and me, to shut down the accounts of bad actors. Put simply, the harder it is to shut down the accounts of copyright pirates, the more money that YouTube makes. Think about it. As a platform that literally relies on user-uploaded content, YouTube's website needs more content to continue growing. Lawful or otherwise, it doesn't matter. In the eyes of YouTube, the only thing that matters is fueling the algorithm. YouTube's executives understand this. It's why YouTube considers watch time as its most important metric. At the end of the day, the name of the game is keeping you on the website so that YouTube can serve you with more ads. Reducing the amount of content available on YouTube's website subtracts from this chief goal. It's really that simple. With this video that you're watching now, I am blowing the whistle. Enough is enough. In my view, there is no difference between a copyright pirate and the websites who seek to harbor them. It is time that YouTube finally be held accountable. It is time that someone finally hold YouTube's feet to the fire, to force it to live up to its own alleged principles. It is time that someone not only call out YouTube for its willful corruption, but actually takes action to put an end to it, once and for all. And so, as you may have heard, I have filed a lawsuit in the Southern District of New York. Two of them, actually. One against YouTube for refusing to apply its copyright policies to the Kremlin's channels, and another against Russia Today, a proxy of the Russian government, for copyright infringement. These lawsuits are a big deal. The outcome of these cases will forever affect the copyright law in this country, and most certainly the very future of the internet. If you are a fellow content creator, please, I am pleading with you, pay very close attention to this video because the outcome of these cases will have a direct impact on your channel. How so? Well, if Business Casual loses, it will become virtually impossible for you to shut down the channels of obvious copyright pirates who brazenly and repeatedly steal your videos. At least, not without first spending hundreds of thousands of dollars and years in litigation for each and every pirate. If this sounds insane to you, or if you don't believe me, buckle up, grab your popcorn, and get ready, because as you will see, this is exactly what YouTube is trying to achieve. YouTube is trying to pull a fast one on all of us in broad daylight. I will not allow it to happen. Before we dive into the details and expose YouTube on its own website, I just want to mention that you don't have to take my word on anything that I mention in this video. All that I ask is that you look at YouTube's own publicly available court filings for yourself. Before we get into things, let me just quickly highlight the 3 principal allegations that I will prove to you over the coming hour with overwhelming evidence. Allegation number 1. YouTube is attacking Business Casual's copyrights to protect and advance the interests of the Russian Federation. Rather than defend a content creator who makes original videos, you'll see firsthand how YouTube has instead chosen to stand behind an obvious copyright pirate, one that is not only funded and controlled by the Kremlin, no less, but one that illegally downloads videos from other channels, erases their watermark, and then removes the collar to try to avoid getting caught. Allegation number 2, YouTube does not equally apply its rules and policies to all channels on its platform. In fact, as you will learn, YouTube actually has a secret off-the-books policy, a policy that is only available to the Russian government and other channels that YouTube deems as special. Under this secret policy, channels belonging to the Kremlin are not actually channels at all, but rather content owners, and therefore can receive up to 35 copyright strikes every single year without ever facing termination. Much more on this later. Allegation number 3. YouTube is trying to make it harder for you to shut down the channels of copyright pirates. As you'll see at the end of this video, YouTube argues that it possesses the right to sub-license your videos, essentially granting YouTube the ability to basically do whatever it wants with your content. According to YouTube's lawyers, when you sign up for YouTube, YouTube can never be held liable for copyright infringement. Why? Well, YouTube's position is that it can just go behind your back and enter into licensing agreements with pirates on your behalf, including with, but not limited to, Russian state-owned television channels without your knowledge, much less your approval. But it gets worse, because after providing pirates with a license to exploit and monetize your video, YouTube also argues that it's entitled to then split the revenue from that pirated content on a 55-45 basis. But not with you, obviously, but rather with the copyright pirate. 55% to the thief, 45% to YouTube, 0% to you. This is what YouTube is actually arguing. It is all in the record. As you can imagine, YouTube is terrified by our lawsuit, and rightfully so. These unlawful policies enable YouTube to generate billions of dollars a year in illicit profits. YouTube knows that losing this case would establish a legal precedent effectively requiring YouTube to shut down the accounts of millions of obvious repeat infringers from its website, just like the channels of those posting feature-length movies and Family Guy episodes that I mentioned earlier. YouTube is determined to make sure that that doesn't happen. Since filing this case, YouTube has been on a relentless crusade to get our lawsuit thrown out at whatever cost necessary, even if it means lying to a federal judge repeatedly to protect Russia. But YouTube will not be successful. At the end of this video, I'll walk you through YouTube's motion to dismiss, point by point, and we'll expose their arguments together. It'll be fun. Without further ado, let's rewind to the beginning of the story so I can explain how this whole situation came to be. It's the last day of 2020. I'm minding my own business, conducting research for our next documentary about Cornelius Vanderbilt, and then this happened. What you're seeing on screen is a television broadcast from a Russian state-owned outlet called RT, or more specifically, RT Arabic. If you're a longtime fan of our channel, this may look familiar. That's because it's actually from our most recent documentary, JP Morgan, How One Man Financed America. For those of you who do not live in the Middle East, RT Arabic may not be familiar to you. It certainly was not to me. For context, RT Arabic is the largest news channel in the Arabic world. With tens of millions of viewers, its influence in the Middle East is literally unparalleled. RT Arabic broadcasted 28 copyrighted scenes from our JP Morgan documentary, nearly a minute and a half of our video, to millions of households via satellite, and of course, through its YouTube channel. Now, before going into the details of these infringements, it's important that you understand the dark forces behind the infringer. See, RT Arabic is but one cog in a much larger machine, and an insidious one at that. A machine whose wheels are greased with lies and whose product is hate. RT, also known as Russia Today, is Vladimir Putin's propaganda machine. Those aren't my words, but the words of the US State Department, intelligence community, amongst many other vocal critics. Even RT's own editor-in-chief, Margarita Simonian, has called RT
an information weapon to be used against the United States.
Okay, so I added the evil laugh track to the end there, but I digress. When it comes to Kremlin propaganda on YouTube, you don't have to look hard to find all kinds of vile content, from US election conspiracy theories to anti-Semitic tropes to deadly coronavirus disinformation, of which there is a lot.
They're creating this microchip and it's going to be inserted into your body. It's going to come with the vaccine.
Children generally do not transmit COVID-19.
Make no mistake, RT is a Kremlin-funded operation with a singular mission: to undermine the interests of the United States of America. If you don't believe that, just follow the money. RT receives hundreds of millions of dollars, or virtually all of its funding, from the Russian government. And that brings us back to YouTube. See, the Kremlin's weapon of choice for disseminating its propaganda is not Twitter, nor is it Facebook, believe it or not. It's YouTube. Unlike other social media platforms where your posts get buried under a sea of subsequent posts, YouTube is different. YouTube videos are evergreen. They aggregate more traffic after their publication, not less. The US Intel Committee is well aware of this, as is YouTube. It's why the US government calls YouTube Russia's vehicle of choice for spreading its propaganda. So with that in mind, let's get back to RT's theft of our videos. After ripping our video from our channel, RT then used a digital eraser to scrape off our watermark, which they replaced with their own watermark. But they didn't stop there. RT also went on to display a banner on screen telling their millions of viewers that the content being broadcasted actually came from their channel, not ours. And not that this would make it okay, but RT also never provided us with any credit in its video description, on screen, or anywhere else. Russia Today did everything they could to pass off our original video as their own. They also went to great lengths to make sure that we'd never find out. If you look closely, you can see that RT removed the saturation from our video, sped up certain parts, and even added a filter effect for good measure. For those of you watching who've been making videos for a long time, like myself, you've no doubt seen these malicious tactics before, perhaps in dealing with copyright pirates who've stolen videos from your channel. RT implemented these changes for one purpose: to avoid getting caught. They've never disputed this, nor have they ever disputed illegally downloading our video. I mention all of this for a few reasons. First, it tells you everything that you need to know about the bad actor in this case, a bad actor that we've been forced to deal with for over a year, not to mention spent hundreds of thousands of dollars suing, which is required under YouTube's policy, which we'll talk about later. I also mention it because it tells you even more about YouTube and its true colors. If this was any other channel, YouTube would have terminated this account. At a minimum, RT has materially and repeatedly violated YouTube's terms of service, but YouTube doesn't care. Instead, YouTube stands behind RT, defending them. As you'll see later, YouTube's lawyers have the gall to argue that RT's admittedly unauthorized use of Business Casual's copyrighted material is somehow justified under the fair use doctrine. It is laughable on its face. I also mention this because it ties into how we discovered RT's infringements. See, normally when someone steals a video from your channel, YouTube alerts you. When you click on the alert, you can see how much of your video was copied, a link to the infringing video, among other resources. But because RT deliberately circumvented YouTube's anti-infringement technology, we never received any such notifications. In fact, the only reason that we discovered RT's infringements is because our director of animation just so happens to live in Morocco and speaks Arabic. It was pure chance that one of our team members just so happened to be watching Arabic television when he stumbled upon the video that he personally edited. Immediately after finding RT's video, he sent me a message. Like any other infringement, I filed a copyright takedown notice with YouTube. 9 days after receiving our takedown request, YouTube removed RT's infringing video and applied a copyright strike to RT Arabic's channel. Now, at this point, we thought that was that. The situation was over, right? And yet, about a week later, I received this email from RT's copyright producer, Ms. Karyeva Albina. Karyeva appears genuinely confused as to why RT Arabic received a copyright strike from Business Casual. Her email states that the content in question is public domain. She wants to know why RT Arabic received a copyright strike. Now, before going any further, it's important that you understand what she's referring to here. What does public domain mean? And as a follow-up to that, do you need to register your work in order to hold a copyright? To help answer these questions is the Russian president himself.
Howdy, comrade. Hello, business casual fans. It is me, Vladdy Daddy. Let's talk about copyright and public domain. When you create something original like a painting or a movie, and then you publish it, your work is instantly protected by this magical legal force field called copyright. This is thanks to a long-standing international agreement called Berne Convention, of which Russia is part of. Under this international treaty, a copyright exists starting from the moment that work is fixed, or, in other words, when it is published, not when it is registered. In fact, the very essence of the Berne Convention is that you do not need to register your work with any government because copyright is automatic, baby! Once you have a copyright, you are granted a temporary exclusive license to that content. It's sort of like being your own oligarch. Now, bear in mind, a copyright is only temporary. Eventually, a copyright will expire and die. Just like my political opponents, am I right? Just kidding. When the copyright expires, it enters what is known as the public domain. This simply means that anyone can now use that content because it is no longer protected by its previously exclusive monopoly.
Thanks, Vlad. Okay, so RT's copyright producer, who ironically appears to know nothing about copyright, is basically saying that Business Casual should not have taken down RT Arabic's video because our video, which again they illegally downloaded from our channel, is not protected by copyright. But that is where Ms. Albina is tragically mistaken. See, RT Arabic's video did not use public domain images from a place like the Library of Congress. Had RT done that, well, that would have been fine. But that's not the case here. To understand why Business Casual's videos are not public domain, all you need to do is give them a brief and casual viewing. To help explain how our 3D visuals are produced is the late JP Morgan.
Oh, hello there, Business Casual fans. I didn't see you there. It's me, John Pierpont Morgan. Let's take a look at some copyrighted material that RT admittedly ripped off from Business Casual's most recent documentary.
What you see on screen is not just an image. If you look closely, you'll notice that it's actually a 3D animation. Let me show you how this works. This scene was created by layering several different images on top of one another into a carefully constructed 3D model. After placing each image and determining the appropriate amount of space between those images, a virtual camera moves through the scene. This 3D visual effect, known as parallax, is what provides Business Casual's visuals with its signature depth of field. This effect cannot be achieved by merely zooming in or panning across a two-dimensional image. Before a photo can be placed into a 3D model, it must oftentimes be completely reconstructed. Business Casual uses digital paintbrushes to painstakingly draw new facial features for various characters, like a new nose for a person's face, a new set of eyes, and so forth. It's as much an artistic process as a technical one. For example, on the left-hand side of your screen, you can see a public domain image of myself from the Library of Congress. Notice the creases in this photo, the pixelation, the not-so-dark suit, and yes, I'll admit it, my less than appealing nose caused by my acne rosacea. Okay, now let's see what Business Casual's restored version looks like. Wow! Just look at this handsome fellow. Notice how the creases have been removed. The background has been darkened. Just look at those piercing eyes and vividly sharp pupils. And check out my suit. It looks like it was just pressed yesterday. After completing the restoration process, the next phase can begin. Image extraction. Business Casual begins by analyzing the scene, specifically looking for people, buildings, and other assets that can be cut out using a digital pair of scissors. These assets will become their own separate images. For example, notice how this crowd shows several groups of people. Some of these spectators are closer to the camera than others, and so business casual begins by extracting this first group of people from the image. This becomes layer number 1. The next group of people are then extracted, becoming layer number 2, and so on. After cutting out each layer, each of these images are then placed on top of one another. This process is known as layering, and it is not only extremely time-consuming, but requires tremendous creativity. If the images are too far apart, the 3D effect becomes distorted. On the other hand, if the images are too close together, the optical effect is not as pronounced. And because no two scenes are ever the same, business casual spends a great deal of time manually tinkering with the optimal distance between the images to achieve the best 3D result. After each layer has been placed, the final phase can begin: animation. Animation is the process of moving a virtual camera through the 3D model, sort of like how a director moves a camera on a movie set by using a camera track. By moving the camera, you can see what was once a 2D image come to life right before your eyes. If a picture speaks 1,000 words, parallax speaks 1,000,000. But business casual goes even further than this, oftentimes combining several different images from different eras to create entirely new works of art. For example, this crowd that you see was never actually present before me. Indeed, this crowd was cut out or photoshopped from a different public domain image, one of Teddy Roosevelt giving a campaign speech in New York in 1905. I wasn't even in New York when this photo was captured. I was vacationing in Monte Carlo in 1912. Business casual combined two completely different photos from two completely different time periods and placed them into one 3D model, creating an entirely new and original scene in the process.
Thanks, JP. So surely this highly creative and original production process is more than you need for warranting copyright protection, right? Well, according to YouTube, no. Or should I say, niet. Indeed, all of this just isn't enough for YouTube. According to YouTube's law firm, Wilson Sonsini, business casual's production process that JP just described is insufficient as a matter of law. Indeed, according to YouTube, our videos are simply unoriginal and not even copyrightable to begin with. Don't believe me? Let me show you a few quotes from YouTube's lawyers, as well as a couple from Russia's, narrated by Morgan Freeman.
The only originality that business casual claims is the way that those images were displayed. Even if RT copied content from business casual's videos, the content is not copyrightable to plaintiff to begin with. Or at least RT has a very strong copyrightability defense. RT also very likely has a very strong fair use defense. Only a few seconds worth from 3 of RT's thousands of videos are in dispute, and those momentary segments consist entirely of public domain images. Business Casual's videos use numerous century-old public domain photographs. RT Arabic's use of short video snippets of historical public domain images and nothing else from Business Casual's videos was fair within the meaning of Title 17, Section 107.
Okay, so full disclosure, the real Morgan Freeman was slightly out of our budget for this video, but it does sound like him, right? Anyway, just for fun, try covering up the names of the attorneys from these quotes and see if you can figure out which are working for the Kremlin and which are working for Google. Good luck. Indeed, lawyers on behalf of YouTube and Russia are each arguing to a federal judge the exact same talking points, that our videos here at Business Casual are unworthy of copyright protection. YouTube's alignment with the Kremlin is not just appalling, it's blood-boiling. YouTube's false and misleading claim that our videos are unoriginal is not just a brazen lie, and an obvious one at that. It's an insult. It's an insult to our team of editors who work around the clock to make original content for YouTube's platform, not to mention an insult to every other creator in the YouTube community. most egregious of all, YouTube's lawyers aren't just trying to mislead anyone, they're trying to mislead one of the most experienced and respected federal judges in America. Worse yet, YouTube is doing it to protect Russia. If you're wondering why, the answer will become evident in the coming minutes. Hint, it's about the money. By the way, should YouTube try to walk back its comments by issuing a statement after this video is published saying, oh, we had no idea, or our attorneys had a misunderstanding, you should know that I provided YouTube's legal team with countless screenshots and recordings showing how our videos are made scene by scene. And I mean that literally. I sent YouTube a Google Drive folder with 28 screen recordings of our raw Adobe After Effects files. These recordings show how each of the 28 scenes that RT infringed are made layer by layer. When YouTube made these false statements to a federal judge, YouTube knew very well that our videos were not mere public domain images. I wish I could say that YouTube's lying stopped there, but it doesn't. My friends, we're just getting started. For example, when YouTube was asked for some context about RT by Judge Ramos, YouTube suggested that RT may not even be funded by the Russian government at all. Here's part of that conference call.
Can I ask you something about TV Novosti? I understand that it used to be, or it is, a state-owned station. So I take it that it's a substantial business and it's not some teenager with a TikTok channel.
So Business Casual alleges that they're funded by the Russian government. I think there's some evidence of that, and I actually believe that there's a notice on YouTube's website that says that RT may be funded in whole or in part by the Russian government. I don't know whether that happens to be true or not, but yes, they are a massive content creator. They have 39 channels. RT Arabic is just one of their 39 channels.
Wait a second, Mr. Molik. YouTube isn't sure about its own disclaimer, which YouTube prominently slaps onto all of Russia's state-owned channels? You know, the one that explicitly warns viewers about RT's funding from the Russian government? Really, Mr. Molik? But anyways, moving on. As mentioned earlier, RT's copyright producer, a woman named Karyeva Albina, sent me an email after we took down RT Arabic's first infringing video. Karyeva asked why RT Arabic received a copyright strike. So, being the forward guy that I am, I replied a few hours later, and I explained exactly why I took down their video. Karyeva, the strike placed on RT is indeed legitimate. Your video was a blatant ripoff of my company's video. If you disagree, feel free to sue, and we will happily see you in court. To my surprise, Karyeva replied the next day.
Dear Alex, yes, you are right. I am terribly sorry about the use of your material in our project. Due to an oversight and misunderstanding here, my colleagues used this fragment without your permission. In this respect, we are willing to make this right with you. We are ready to pull our entire project from circulation and remove your copyrighted material if you retract the strike.
A few hours later, Karyeva sent me another unbelievably incriminating email.
Following up on my previous email, I'd like to add that my colleagues filed a counterclaim by mistake yesterday, so please ignore it.
Within 24 hours, Russia Today, to its credit, did the right thing and retracted their counter notification. Side note, a counter notification is basically a short message that you send through your YouTube dashboard where you explain your reasoning as to why you are disputing the takedown of your video. More on this later. As of the day of making this video, RT's counter notification concerning its first infringing video remains retracted, as it should. And just like that, RT has a copyright strike. For those of you who are not content creators and may not be familiar with YouTube's copyright policies, RT now has a very serious issue on its hands. And that's because YouTube's policy explicitly states, quote, if a user gets 3 copyright strikes in 90 days, their account, along with any associated channels, will be terminated. After 3 strikes, YouTube provides you with a 7-day courtesy period. Once this period is over, it's Dostovanya. This is YouTube's published policy. It is simple and straightforward. 3 strikes, you're out. Unfortunately for RT, they have 39 channels, as confirmed by YouTube. Collectively, these 39 channels receive over 5 billion views every year, representing the cornerstone of the Kremlin's propaganda apparatus on the internet. These channels are, without a doubt, the backbone of Putin's propaganda machine. And here's where things get really interesting. Unlike other policies on YouTube's website, like its terms of service or community guidelines, which are contracts that are governed under the jurisdiction of California, having and enforcing a repeat infringer policy is a matter of federal statute. Under Title 17, Section 512, YouTube must adopt and reasonably implement a policy that calls for the termination, in appropriate circumstances, of channels that are repeat infringers. If YouTube fails to, quote-unquote, reasonably implement its repeat infringer policy, then YouTube can be held liable, specifically by forfeiting the DMCA's safe harbor, which is sort of like a liability force field, if you will, protecting YouTube from lawsuits. More about this at the end of the video, but for now, let's get back to Russia. As mentioned, RT now has 1 copyright strike. Not great, but not terrible. After all, if RT can avoid receiving 2 additional copyright strikes within 89 days, then one of those strikes will fall off, and their 39 channels will be spared from termination. But as fate would have it, RT's been stealing our videos for years. A couple of weeks after taking down RT's first infringing video, my team stumbled upon another infringing video that RT posted. This one infringed an entire scene, approximately 7 seconds from our video about John D. Rockefeller, which is also our most popular video with over 5 million views. Shortly after discovering that video, we found, you guessed it, yet another infringing video. This one, a YouTube live stream, featuring nearly 9 minutes of our JP Morgan documentary. To make a long story short, RT received 3 copyright strikes from Business Casual within 52 days. At this point, the Kremlin was beginning to realize that they had a major problem on their hands. With the shutdown of RT's 39 channels looming closer by the day, the Russians were left with only one option to save their propaganda machine. RT had to muster up a completely meritless fair use defense and file disputes in bad faith concerning its 2 other copyright strikes from Business Casual. As a reminder, the Russians already retracted their counter notification concerning their first infringing video. Now, before going any further, it's important that you understand the fair use legal doctrine and its role in the DMCA's takedown and counter notification system. It may sound complicated, but I promise you it's not. To help explain once more is the Russian president.
Howdy, comrade. As I talked about earlier, copyright provides you with a temporary exclusive license to your original creations. But there is one notable exception to this exclusiveness, and it is called fair use. Basically, fair use is a legal defense to copyright infringement. It allows you to legally use another person's copyrighted material without their permission. Now, in order for your use of another person's copyrighted material to be considered fair, it's the name of fair use. A court will consider 4 factors. Factor number 1, the purpose and character of your use of the copyrighted material. Put simply, did you transform the copyrighted material? If so, how much and how? This is critically important. It's the first thing that the judge will observe. For example, consider this picture of a peaceful Ukrainian city before Russia's invasion. Say that you want to incorporate this copyrighted material into your own art. A court will ask, did you add something new? Or is the original photo still the dominant work that is present? The more that you transform it, the more likely it is that your version will be considered fair. For example, let me show you what this peaceful Ukrainian city now looks like after my military operation. As you can see, these 2 photos are now very different. This is a great example of a very strong transformation defense. Factor number 2 is the nature of the copyrighted work. In other words, is the copyrighted material historical in nature, or is it creative, like fiction? As a general rule, copyrighted works that are factual receive less copyright protection. Allow me to explain. Consider 2 movies. The Hunt for Red October, a fictional American spy thriller about the Soviet submarine, and First Man, a historical film about the United States being the first country to land. First Man is a historical film, but it still receives the same level of copyright protection as a fictional one, like The Hunt for Red October. Right? Because both works are creative and original. Much the same, business characters really might be about history, but its copyright protections extend to its beautiful 3D visuals, which boast very strong copyright protection. Factor number 3 deals with the amount of copyrighted material that you use. The more of someone else's copyrighted content that you appropriate, the less likely it is to be considered fair use. Now, to be clear, that's not to say that using just a little bit of copyrighted content is okay. As YouTube's Help Center correctly states,
one of the biggest myths about fair use is that there's a minimum amount of time you're allowed to use someone else's copyrighted work. But despite what some people may think, there is no duration which you can use someone else's content that is automatically protected under fair use.
When it comes to using other people's copyrighted material, remember this: less is best. Factor number 4, the effect of your use on the market. If your use of the copyright holder's material harms or usurps the market for the original work, it is very likely that your use is not fair. It's that simple. So, in a nutshell, those are the 4 factors of fair use. Remember them wisely, Koeltl.
Thanks, Vlad. Okay, so let's say that you make a YouTube video and you use someone else's copyrighted content. Before you publish your video, you go through the 4 factors of fair use to diligently ensure that your use of the other person's material is fair. You are not a bad actor. Your intent is not to infringe another person's copyrights to enrich yourself. On the contrary, your genuine intent is to enrich society with your unique ideas and criticism of their work. By the way, this is the genius of fair use. Without it, it would be impossible for people like YouTubers or newscasters to comment on matters like breaking news out of fear of committing copyright infringement. Because criticism is heavily protected under the fair use legal doctrine, you believe that your use is fair, so you go ahead and publish your video. The copyright holder, on the other hand, watches your video and disagrees. They think that you used too much of their video and that your use is not fair. So they file a copyright takedown request with YouTube. In doing so, the copyright holder signs a sworn statement under penalty of perjury certifying that they are filing their takedown request in good faith. A couple of days later, YouTube expeditiously removes the content from your channel as required by law. Well, sort of. Technically, YouTube doesn't have to do this, but if it does not do so expeditiously, it can be sued. So usually, YouTube complies. You then get an email saying that your video was removed for copyright infringement. You also now have a copyright strike on your channel, but you disagree. You believe that your use was in fact fair and that the takedown was wrong. So you file a dispute, also known as a counter notification, through your YouTube dashboard. It's very easy. All you have to do is briefly type your reason for why you believe that your use was fair, and with just a couple of clicks, you hit submit. Just like the rights holder who filed the takedown request, you also have to sign a sworn statement under penalty of perjury certifying that you are filing your dispute in good faith. After filing your dispute, YouTube automatically forwards your message to the copyright holder. From here, the copyright holder now has 2 choices: file a lawsuit against you or do nothing. If the copyright holder does nothing, YouTube will reinstate your content within 10 business days as required by the DMCA. Lawsuits are pretty rare. It's a real inconvenience, it's very expensive, and according to YouTube's own help center,
it doesn't happen often.
But if the copyright holder does decide to sue you, they must provide a copy of this lawsuit to YouTube, and quickly, specifically within the 10 business day period after receiving your notification. This is the law. YouTube will not reinstate your content if the rights holder files a lawsuit against you within this 10-day window. Now, here's the important part to understand about this whole thing. Until you are held liable in court for copyright infringement, which can take the rights holder years and millions of dollars to accomplish, you do not have a strike on your channel. Why? Well, because per YouTube's policy, the burden of proof no longer lies with you, but rather with the rights holder. Now, in this example, neither party is being malicious. The copyright holder genuinely believes that you committed copyright infringement, and you genuinely believe that you did not. Both parties are acting in good faith. But unfortunately, that is not always the case. Bad actors like RT are abusing the DMCA by filing laughably false DMCA notifications in obvious bad faith after receiving 3 copyright strikes. Why are bad actors like RT doing this? Well, because, as mentioned earlier, YouTube's policy is 3 strikes, you're out. If the bad actor does not dispute their status as a repeat infringer, YouTube will terminate their account. Much more on this in the coming minutes. YouTube would later argue in its motion to dismiss that when RT filed its counter notifications, RT's copyright strikes were basically reclassified from strikes to allegations of infringement. Therefore, the repeat infringer is not actually a repeat infringer, but rather an alleged repeat infringer. In a conference call with Judge Ramos, here's how YouTube's lawyer explained their position.
In this case, TV Novosti has submitted counter notifications under penalty of perjury, disputing Business Casual's claims that an infringement occurred. Now, I understand that with respect to one of them, TV Novosti withdrew one of the counter notices. That's true. But that's only with respect to one of their videos. For two other infringing videos, they submitted counter notifications and never withdrew them. And I suspect that the reason why, Your Honor, is because even if they copied content from Business Casual's videos, the content is not copyrightable to Business Casual to begin with. Or at least, RT has a very strong copyrightability defense. RT also very likely has a very strong fair use defense, which is something that is being litigated in the related case. We are not judge, jury, or executioner, and the DMCA does not require us to be judge, jury, and executioner. That wouldn't be appropriate. In this case, we have one user who has submitted 3 takedown notices with respect to just a few seconds worth of content, and those takedown notices are being disputed. It is absolutely appropriate in that circumstance to say, we don't know who's right, there are arguments on either side, go litigate your case, and then let us know how that turns out. YouTube is nothing more, at least with respect to TV Novosti's videos, than an automated hosting platform.
At first glance, this explanation for why YouTube is not terminating RT's channels may sound perfectly appropriate, but there's only one problem. Almost everything that YouTube's counsel just said is simply not true. At the end of this video, I'll talk more about YouTube's false and contradicting statements to the court, but 3 things must be said here. First and foremost, what YouTube lawyer Jason Mollick conveniently forgot to mention is that YouTube has actual knowledge of the fact that RT's third infringing video exploited the exact same 28 copyrighted scenes as RT's first infringing video. This is a very important detail because, as you already know, RT retracted their counter notification concerning that admittedly infringing video. RT has already conceded that that video was a blatant ripoff of Business Casual's copyrighted material, and that the copyright strike placed on that video was indeed legitimate. Now you may be saying, but Alex, hold up. If RT's first infringing video used around 1.5 minutes of Business Casual's JP Morgan video, then how can RT's third infringing video exploit those same 28 scenes? I thought you said it was about 9 minutes. The answer is because RT's third infringing video was a YouTube live stream, which looped 6 times. We have a 100-hour screen recording proving this. YouTube has seen the recording. How do we know this? Because I sent the evidence to YouTube and YouTube replied. YouTube's response constitutes actual knowledge. As you can see on screen, RT's 2 infringing videos are pixel for pixel identical. Both exploit the exact same 28 copyrighted scenes from our JP Morgan documentary. There is no genuine dispute about this, nor could there ever be. I mean, you can literally see the videos side by side. It is obvious. And yet, despite this fact, RT still, to this day, refuses to retract its counter notification concerning its third infringing video. Why? Well, apparently out of fear that doing so would then classify it as a repeat infringer. So that's the first thing. Secondly, what YouTube's counsel knows very well is that our videos are not just copyrightable, but in fact protected by our copyright registrations granted by the US Copyright Office. As mentioned earlier, we didn't just provide YouTube with a detailed description of how our videos are made and mere copies of our registrations. Rather, we sent YouTube 28 separate screen recordings. These recordings show the deconstruction of each of our 3D parallax models in Adobe After Effects. You do not need to be an attorney, much less a copyright attorney, to recognize that Business Casual's original scenes are protected by copyright as a matter of law. If YouTube's lawyers do not understand this, then they either need new glasses or they need to go back to law school. Thirdly, YouTube is also well aware of the fact that RT did not just exploit just a few seconds from our videos. That is just a flat-out lie. At least 2 of RT's infringing videos exploited nearly 1.5 minutes of our copyrighted material. That is a far cry from just a few seconds. But putting that aside, even if YouTube's claim was true, that RT used just a few seconds of our video, it's still blatantly misleading because it takes a tremendous amount of time to create those mere seconds of copyrighted material. So with those 3 things in mind, let's take a quick look to examine RT's very strong fair use defense in the words of YouTube. Russia argues that our case should be dismissed for several reasons. Argument number 1, RT should be allowed to profit from Business Casual's videos because RT is a non-profit. Argument number 2, Business Casual's copyrighted material was not the dominant thing shown on screen. Argument number 3, RT's allegedly infringing videos are critical of JP Morgan and Rockefeller. whereas business casuals videos praise their subjects, and thus RT's use is somehow transformative because it serves a different purpose. Argument number 4, business casuals visuals are merely public domain images. Argument number 5, business casuals videos are historical in nature and thus worthy of less copyright protection. Argument number 6, RT is a news agency, and therefore it's entitled to monetize business casuals' copyrighted material without permission from business casual or credit to business casual. Argument number 7, RT only used business casuals' copyrighted visuals and nothing else from business casuals' videos like its audio, script, etc. With all the rubles in the world, this was apparently the best defense that RT could come up with. Pathetic. I can make a whole separate video about RT and its fair use defense, but in the context of exposing YouTube, I think it's worth taking just a minute here to address RT's arguments. First, being a non-profit does not give you the right to profit from another person's copyrighted material. Second, I'm not sure how RT can claim that our visuals are not the dominant thing shown on screen, when in fact our visuals are the only thing shown on screen. You know, minus our watermark. Third, our videos do not praise their subjects. Not that it would make any difference. By watching our videos on YouTube, you can see that we actually describe Rockefeller as a bloodthirsty monopolist who strangled his competitors, and Morgan as a war profiteer, like the time when he exploited the Union Army when it was desperate for rifles. Fourth, and I promise this is the last time that I'll say this, our videos are not public domain images. But don't take my word on this, just ask RT's own copyright producer who admitted in writing that our documentary is in fact our copyrighted material. Her words, not mine. Fifth, the fact that our documentaries relate to history is completely irrelevant. Our copyright registrations protect our 3D visuals, specifically the end product, not any process or trade secret involved in making this content, as RT also claims. Our 3D visuals are undoubtedly original creative works, and they are protected as such. Sixth, even if RT is a news agency, and that is quite the stretch, its argument is still futile because the infringing content in question is not actually news. RT's infringing videos discuss the lives of JP Morgan and Rockefeller, both of whom died over a century ago. That's not news, that's history. Per RT's logic, every copyright pirate should just register as a news agency to protect itself from copyright claims. But of course, that's not how the law works. 7, and this is my favorite argument, RT claims that their use of our copyrighted material is fair because they didn't steal anything else from our video, like our script, our narration, and so on. But of course, RT's listing of all the copyrighted assets that they didn't blatantly rip off from our video is just an attempt to distract from the copyrighted material they've already admitted to blatantly ripping off. It's almost like saying, Your Honor, while it's true that my client robbed the bank's vault, you should know that my client did not rob the bank's tellers or the bank's manager on the way to his getaway car. Seriously, that's basically what they're saying. And by the way, the most hilarious part about their argument here is that it's not even true. If you look at RT's script, an English translation of which they provided to the court, you can see that RT did steal our script, or at least part of it. There are several parts of their video which use almost verbatim quotes from our video. But yes, those are RT's arguments in a nutshell. Meritless. They're so meritless, in fact, that YouTube's statement about RT likely having a quote-unquote very strong fair use defense goes from being clearly wrong to, dare I say, highly suspicious. Like, for one thing, why is YouTube supporting RT's fair use defense? YouTube is not even named as a defendant in that separate lawsuit. Think about it. If YouTube wants to win its case against business casual, this is not an argument that YouTube needs to make. I thought YouTube was just an automated hosting platform. Didn't we just hear YouTube say that it would be inappropriate for YouTube to be the judge, jury, and executioner? If that's the case, then why is YouTube telling a federal judge their legal opinion about RT's very strong fair use defense? What happened to YouTube not being able to decide what is fair and what is not? So why is YouTube echoing RT's fair use defense? Could it be because YouTube doesn't want business casual to win its case against RT? I believe the answer is yes. Why? Well, we don't have to speculate. The Kremlin has publicly threatened countless times to ban YouTube and Google throughout Russia if YouTube terminates RT's channels. I'm sure that some of you may be asking yourselves now, well, Alex, why would Russia even try to fight this case? I mean, obviously, their use of business casual's content was not fair, so why even fight? And I think the answer to that question is that winning this lawsuit was never RT's goal. RT's only goal is to delay their termination. And in that respect, they've been successful. The Kremlin is simply trying to preserve its YouTube propaganda machine for as long as it can, which means doing everything within its power to delay being classified as a repeat infringer. Every day that RT skirts termination is another day that it can continue to undermine the United States. And that's actually a perfect segue to explain why the DMCA fails rights holders in cases like this. America's takedown and counter notification system is by no means perfect. Clearly, if it were, I wouldn't have had to make this video. But by and large, it's a fairly decent system. I think it works well for resolving the vast majority of copyright disputes between domestic parties, many of which are genuine disputes over fair use. Unfortunately, the DMCA completely fails rights holders in the 0.01% of extraordinary cases like it does here. And that's because, as mentioned at the beginning of this video, the pirate in this lawsuit is not your average pirate. As a reminder, we're talking about a YouTube channel that is owned and controlled by an authoritarian regime that poisons its political dissidents and is actively committing war crimes. The Kremlin does not care about the legal consequences of filing completely bogus counter notifications in obvious bad faith under penalty of perjury. You have to keep in mind, RT submitted its counter notifications in Russian from Moscow. The US doesn't even have extradition with Russia. And so the inherently obvious flaw with the DMCA's takedown and counter notification system is that it assumes that those who are party to the system actually respect the rule of law in which the system is governed. But Russia does not respect our country, much less our country's judicial process, and most certainly not the Southern District of New York. I think this fact is best illustrated by just how hard it was to get this lawsuit started. When RT filed its counter notifications, RT signed sworn statements under penalty of perjury, certifying that they were filing their disputes in good faith. It wasn't true, but they did it anyway. They also checked a box in which they explicitly agreed to accept service in any judicial district in any federal court where YouTube is located, which includes New York. And yet, despite this, RT still dodged our process server for over a month. RT wouldn't even authorize its own lawyer in New York to accept a courtesy copy of our complaint. Just to give you an idea of how frustrating this last year has been, our process server had to camp outside of RT's office in DC and chase these cowards for over a month as they ran away to try to avoid getting served. We had to get a court order for alternative service just so that we could serve our lawsuit over email. But it gets even worse, because after we eventually received permission to serve our complaint over email, RT then tried to argue that jurisdiction was not proper. Why wasn't jurisdiction proper? Well, according to RT, it is actually a foreign sovereign, and therefore immune to the laws of the United States. The Russians would later drop this argument for a number of hilarious reasons that I won't get into. I can go on, but you get my point. In the eyes of the Russian government, filing laughably false DMCA counter notifications under penalty of perjury from the comfort of Moscow is of zero concern. It's fair game. Again, all that Russia needs to do to preserve their 39 channels is file bogus counter notifications through their YouTube dashboard, which only takes a minute, and then with just a couple of clicks, they are spared from termination. That's it. From the moment that RT disputes its copyright strikes, they can sit back and drink vodka. Under YouTube's policy, the burden of proof has shifted. The burden of proof now lies on business casual to go out and spend millions of dollars and years in litigation to adjudicate what everyone can clearly see is an obvious repeat infringer. If business casual doesn't go through this ridiculous adjudication process, then YouTube will not terminate the pirate's channel, regardless of the obviousness of the infringements. This is so wrong. In cases like this, where the repeat infringement is obvious and where bad faith is clearly evident to any reasonable person, then the circumstances for termination are appropriate as a matter of law, and the repeat infringer need not be adjudicated. But YouTube disagrees. Now, you may be saying to yourself, well, Alex, surely there must be some consequence for filing laughably false counternotifications in bad faith. And you'd be right, there is. Under Title 17, Section 512F, if a court finds you liable for filing false counternotifications, then you can be on the hook for paying the plaintiff's legal fees, which can quickly add up to hundreds of thousands of dollars. I can attest to this. Now, for the vast majority of would-be repeat infringers, this is enough of a deterrent to at least make you think twice before filing bogus disputes. But once again, RT is not your average pirate. The Kremlin is not deterred by the threat of paying a few $100,000 or even millions of dollars of my legal fees, especially when you consider that RT profits almost $1 million a month from its 39 channels. And so, in closing on this topic, When you are dealing with a bad actor with an infinite bank account, one that can dispute its copyright strikes in bad faith with no concern whatsoever from a non-extraditable country and can print rubles to fund its legal defense, then you have a problem, because there is no deterrent to stop the repeat infringer. But hey, the law is the law. It is what it is. So RT filed its counter notifications, and now we had to respond. And respond we did. As explained earlier, Business Casual only has 10 business days to file its lawsuit and provide a copy of the lawsuit to YouTube after receiving RT's counter notifications. If we don't do this, then we forfeit our rights under the law, and RT's infringing videos are reinstated. Of course, we did not want our videos back on Russian state television, so doing nothing was certainly not an option, and thus we had to respond. But before filing our case, I wanted to see if we could resolve this without having to go to court. So I lawyered up and we sent a cease and desist to RT's law firm, the Moscow branch of White & Case. We explained to RT's lawyer that shutting down Russia's channels was not our goal. We explained that the termination of RT's 39 channels was simply a byproduct of YouTube's DMCA required policy. In these letters, which you can read for yourself, we could not have made our position more clear. Business Casual simply does not want its content on Russia's state-owned channels, and that despite RT's years of stealing our videos, we are still open to the idea of a settlement, one that would help RT avoid the termination of its 39 accounts. We also warned RT that if they refused to withdraw their counternotifications by day 10, then they'd be leaving us with no choice but to sue. After sending our first letter, a few days go by, and we hear nothing. So my lawyer sends another letter to RT's law firm. We called again. We sent another email. Russia's response? Silence. RT and its counsel ignored every single one of our attorney's emails, phone calls, and letters. Apparently, the Kremlin thought that we were bluffing and would not actually file a lawsuit. And so, after exhausting every single avenue under the sun for trying to resolve this in good faith without litigation, I had no choice. I had to file suit because that's the law. After filing our case, I began emailing my contacts at YouTube and Google for help. I provided YouTube's executives with screenshots of RT's infringing videos side by side our original videos, along with side-by-side video recordings. I even sent Wayback Machine forensic archives. Of course, I also sent over a copy of our lawsuit against RT. And just in case these executives had forgotten what YouTube's policy states, I also sent along screenshots of YouTube's 3-strike repeat infringer policy right next to YouTube's own emails proving YouTube's actual knowledge. Most important of all, I provided these executives with a screenshot of a bombshell email sent to Business Casual from another RT representative. In this email, RT's representative admits, in writing, that the reason why RT is refusing to withdraw their counter notifications is because, quote, it is our client's understanding that withdrawing the counter notifications will result in YouTube terminating RT's channel. Ladies and gentlemen, this email right here is the smoking gun. RT is admitting that their counter notifications are meritless. By the way, take special note of how RT does not mention a single word about actually believing in their fair use argument, which again, they sent to YouTube under penalty of perjury. Rather, the sole explanation that RT provides as to why they are refusing to withdraw their counter notifications is because, quote, withdrawing the counter notifications will result in YouTube terminating RT's channel. This email sealed RT's fate. After YouTube received everything that I just mentioned and a heck of a lot more, 2 Australian-based YouTube executives, Mel Silva and Ed Miles, got back to me. In this email thread, Ed introduces himself and says, let's get to the bottom of this. That's my Australian accent. After exchanging some more emails, I provided Ed with a 10-page timeline of material events concerning the entire situation. Not long afterward, Ed replied and suggested that we should hop on a voice call. But before we could schedule a time to speak, he sends me another email and confirms that YouTube held an internal call on March 17th about RT's years of infringing activities. This email is yet another smoking gun because it proves that YouTube doesn't just possess actual knowledge and red flag knowledge about RT's years of flagrant disrespect for our intellectual property, but also that YouTube talked about it internally. In a bizarre twist, YouTube would later suggest that Business Casual has never provided YouTube with the links to the specific infringements in question. But of course, the facts tell a very different story. It's almost as if YouTube's lawyers, have never heard of a thing called screenshots. I'm starting to think that these people live in their own little metaverse. After reviewing the evidence and holding an internal meeting about it, YouTube's executives evidently agreed with me. RT had to go. But rather than terminate all 39 of RT's channels like YouTube's policy requires, YouTube made the decision only to shut down RT Arabic. Apparently, YouTube made this decision out of fear that terminating all 39 of RT's channels might result in retaliation from Russia. Following YouTube's internal meeting on March 17th, RT Arabic's termination date was scheduled for the end of the month, March 31st of 2021. But news of RT Arabic's upcoming termination was apparently leaked to other Google divisions because less than 48 hours after YouTube's internal meeting, I started receiving very strange emails from YouTube's Moscow office, like this one. Quote,
Hello, Alex. My name is Elisabet Lykhina, and I am a YouTube partner manager for Europe, Middle East, and Africa. I would like to kindly get in touch with you to discuss the current case of 3 YouTube strikes that your channel, Business Casual, has recently sent to a Russian Commonwealth of Independent States news YouTube channel, RT Arabic. Can you please get back to us to discuss details? We would like to bring additional insights to this case. Your answer will be strongly appreciated. Thank you.
Elisabet's email can only be described as perplexing and disturbing. First and foremost, why is a top executive from YouTube's Moscow office reaching out to an American citizen on behalf of a registered foreign agent in her official capacity as a Google executive from her Google email address to try to resolve copyright issues for the Kremlin's YouTube channels, or to use her own words, bring new insights to the case, referring to my lawsuit? Since when did YouTube executives begin acting as mediators in copyright disputes? I thought YouTube's website explicitly states, quote, can YouTube determine copyright ownership? No, YouTube isn't able to mediate rights ownership disputes. Huh, now isn't that interesting? It's almost like YouTube is not telling the truth. Curious as to who this mysterious person was, I Googled her. After finding Elisabet's LinkedIn, I learned that prior to joining Google, she worked as a managing producer of Kremlin propaganda for a state-controlled Russian television network with close ties to, you guessed it, Russia Today. You can't make this stuff up. My friends, the significance of Elisabet's email cannot be overstated. It effectively destroys the very foundation of YouTube's entire legal defense. Think about it. To quote YouTube's motion for dismissing our lawsuit, YouTube did nothing more than provide a hosting platform. In other words, YouTube is saying, hey, we don't get in the middle of copyright disputes between creators. But as you can see for your own eyes, that is, once again, simply not true. At least certainly not in this lawsuit. And so, the way I see it, YouTube is not entitled to enjoy the DMCA's safe harbor protections provided to online platforms when YouTube's own emails prove that YouTube is engaged in the very activity that its own website explicitly prohibits. More on this later. If you still have any hint of doubt about RT being a repeat infringer, then this next part will fix that. Because on March 31st of 2021, RT Arabic was terminated for being a repeat infringer in accordance with YouTube's 3-strike policy. This was done intentionally, not in spite of RT's admittedly fraudulent clarifications, but because of them. If you tried going to RT Arabic's channel, this is what you saw. Quote, this account has been terminated because we received multiple third-party claims of copyright infringement regarding the material the user posted. Fortunately, the Kremlin understood this reason and took it with stride. Just kidding. RT's termination sparked pandemonium. All hell broke loose across Russia. Within hours, it was national news. The Kremlin was enraged by YouTube's decision to shut down one of its channels, calling the move an act of Western aggression. How dare YouTube follow its own policies prescribed under federal statute? What kind of evil monopolist corporation would do such a thing? Maria Zarkova, the official spokeswoman on behalf of the Kremlin's Foreign Ministry of Affairs office, personally took to Facebook and branded me as an enemy of the Russian Federation. Indeed, according to Zarkova, I am an internal American terrorist who rapes free speech in an effort to violently harass Russia to try to censor Russian state media. By the way, I love how our statement goes on to reference the hashtag #MeToo movement and Black Lives Matter. Like what? Anyway, this lady's a nut, but she also has many followers. Following her comments, thousands of misinformed Russians took to social media to condemn YouTube's Western censorship. Now, of course, RT's termination had nothing to do with Western censorship and all to do with RT's years of brazenly stealing our videos, but it didn't matter. The damage was done. RT could have done the respectable thing and informed its viewers of the truth that RT was terminated because they had been stealing another channel's copyrighted videos for years and had undertaken malicious steps to hide their activity. But then again, we're talking about the Russian government. A copyright infringement lawsuit would never fit the Kremlin's narrative. So rather than face the music and take responsibility for its actions, RT instead chose to do what it does best: spread disinformation. Immediately after RT was terminated, RT spun up an elaborate conspiracy theory, a blatant hoax accusing Business Casual of being backed by a large financial institution. Indeed, according to RT, I am crusading against Russia for political reasons? Who knew? Look, I'm no fan of Russia, especially with everything they've done to Ukraine, but the simple fact of the matter is that we've never even mentioned Russian politics on this channel before our lawsuit. RT did not receive 3 copyright strikes because we forced them to steal our videos. They made that choice, just like how they made the choice to ignore our letters, forcing us to sue them. If I was on some crusade to shut down Russian state media, then why did I repeatedly propose a settlement before filing our case specifically to, quote, work out a deal with RT to prevent the termination of RT Arabic and RT's associated channels? My friends, contrary to Russian state media, which you should always consume with a pinch of salt by the way, it was never my goal to shut down Russia. Believe it or not, I have better things to do. For the past 2 years, I would have preferred to have made new videos for our channel. From day one, I've only been defending Business Casual's copyrights. That's it. But hey, that's the Kremlin that we all know. Not a surprise. But what is surprising is what happened next. The Russian government made YouTube an offer that it could not refuse. Bring back RT Arabic immediately, or face the wrath of Russia. This is not my theory. The Russian government would later confirm it on social media. And to my genuine surprise, YouTube caved. Just 3 hours and 22 minutes after the Kremlin's orders were published online, orders demanding that YouTube quote-unquote stop censoring Russian media, YouTube's Moscow office reinstated RT Arabic. This sent me over the edge. How could YouTube do this to me? YouTube's executives exchanged hundreds of pages worth of emails with me specifically about RT's obviously infringing activity, end quote. YouTube literally had an internal meeting about this. So surely this was all a big misunderstanding. It would only be a matter of hours before YouTube's North American team would step in and fix this mess, right? And yet, 461 days later, and here we are, still waiting for RT's 39 channels to be terminated in accordance with YouTube's 3-strike policy, and this time permanently. Now, a quick side note here. As of the day of making this recording, YouTube has temporarily blocked worldwide access to all videos posted on Russia's state-owned channels. This was done a few months ago following Russia's invasion of Ukraine. It's a step in the right direction, for sure, but a temporary blocking of RT's videos is not the same as the termination of their accounts, not even close. Now, I don't want to go off on a tangent here, but on the topic of RT's videos being temporarily unavailable for violating YouTube's rules, I'd be remiss if I didn't invite you to check out an email that I sent directly to the CEO of YouTube and the board of Alphabet. In this email, I call out dozens of videos published by RT that violate YouTube's COVID-19 misinformation policy, videos suggesting that the American government invented COVID-19 as a bioweapon to be used against the Iranian people, not to mention videos promoting completely unsubstantiated medical claims that America's vaccines are 10 times more likely to result in death compared to Russia's Sputnik vaccine. I only mention this because a representative on behalf of YouTube's CEO and the board of Alphabet responded. The representative acknowledged my reports and informed me that in light of my unrelated copyright lawsuit, YouTube would not be applying any of its COVID-19 medical misinformation policies to any of RT's channels. Apparently, I would need to reach out to YouTube's law firm and file another lawsuit against YouTube just to remove these dangerous videos. After receiving this email, I asked my friends, people who are not associated with our company, to join me in flagging RT's videos. They never received any response. In fact, despite our hundreds of reports submitted by multiple people, not a single one of RT's deadly videos was ever removed. The videos are still on YouTube, just like all of RT's videos. They're just temporarily out of view. Now guys, while it's true that RT is gone, at least for now, it's important that we not forget about this 346-day period spanning from March 31st of 2021 through March 11th of 2022. This period matters. It matters because it represents the day that YouTube made the decision to violate its 3-strike policy by reinstating RT through the day that all of RT's videos were blocked globally. For nearly an entire year, YouTube complied with an order from the Kremlin not to terminate RT's channels following its explicit threats that Google's billion-dollar business in Russia would be banned if YouTube did not immediately stop its Western censorship. I'm going to say that again because it's important. YouTube complied with a written order from a senior Kremlin official with knowledge that that order would have a direct effect here in the United States, affect an American citizen, and violate YouTube's repeat infringer policy. This needs to be investigated. During this 346-day period, RT received billions of views across its 39 channels. Hundreds of thousands of Americans died from COVID-19. Many have argued that much of that was fueled by Russia's disinformation. And what was YouTube's response? Well, first and foremost, to incentivize RT to continue engaging in its unlawful activities. YouTube not only knowingly allowed Russia to weaponize its platform to undermine the United States, as evidenced by YouTube's response to my reports and then later silence, but also YouTube actually helped RT monetize its deadly videos with ads. That's right, RT's 39 channels enjoyed unrestricted access to YouTube's partner program. Ironically, RT's COVID disinformation even featured ads from the American CDC, not to mention dozens of prominent advertisers like Oracle, Monday, Best Buy, amongst dozens of others. By the most conservative estimate, RT and YouTube each profited around $1 million a month, or about $14 million over this 346-day period. For nearly an entire year, RT was able to undermine the interests of the United States, spread disinformation in an effort to kill as many Americans as possible, and make millions of dollars in the process. And why were the Russians able to pull off this heist? Because YouTube made the choice to look the other way. YouTube knew exactly what RT was up to. YouTube knew that RT constantly violated its terms of service. YouTube knew that RT never showed a lick of respect for its COVID disinformation policies. YouTube knew that RT was subject to termination under YouTube's 3-strike repeat infringer policy. And when it became obvious to YouTube that RT was subject to termination under those rules, what did YouTube do? They changed them. When YouTube was caught red-handed for not enforcing its repeat infringer policy, its lawyers concocted a new one that provides RT with up to 35 copyright strikes every single year. More on this later. Was YouTube's decision to reinstate RT because of the Kremlin's pressure? I think anyone can reasonably infer that it's certainly plausible, if not probable. But that's why discovery is necessary in this case. I agree wholeheartedly with what Ed Miles said in his very first email to me. Let's get to the bottom of this. On April 2nd of 2021, less than 48 hours after RT's reinstatement, I penned a 23-page letter to Alphabet's board of directors. In this letter, I reminded Alphabet's board that YouTube must apply its repeat infringer policy to RT's channels pursuant to YouTube's obligations prescribed by the DMCA. If they refused, then I would file a lawsuit and strip YouTube of its DMCA safe harbor protections. A couple of weeks later, a representative on behalf of Alphabet's board responded. YouTube would not be taking any further action against RT without a court judgment. Now keep in mind, this is despite the fact that nowhere in YouTube's policy does it state that a rights holder like myself needs to get a court judgment to remove a repeat infringer. In fact, this email directly contradicts YouTube's policy, which again is simple and straightforward. If a user gets 3 strikes in 90 days, their account, along with any associated channels, will be terminated. Essentially, YouTube's position in this lawsuit is that it will not terminate the channels of any alleged pirate if they submit a counter-notification, regardless of the obviousness of the counter-notification's fraudulence, even if the bad actor concedes in writing that they submitted their counter-notifications by mistake and are only refusing to retract them to avoid termination. And that is the issue. 8 days after receiving Alphabet's email, I filed my lawsuit as promised. So what is YouTube's response to all of this? And more importantly, what is the judge's opinion? Starting with YouTube. According to their motion to dismiss, this entire lawsuit, it's all just a red herring and nuisance litigation. I disagree. YouTube knows that the facts of this lawsuit are not on its side, nor are YouTube's own policies, and most certainly not the law. So what do you do when all these things are against you? Well, you invent new facts, new policies, and yes, a new version of the law. And that is exactly what YouTube has done. We don't have time to go through all of YouTube's arguments. Frankly, they're not worth your time, but let's address a handful of them. YouTube argues that our case should be dismissed because, argument number 1, a policy that allows for special channels to receive up to 35 uncontested copyright strikes every year is a reasonably implemented policy. Argument number 2, the termination of RT's 39 channels is inappropriate. Why? Well, because doing that would also entail the removal of thousands of perfectly lawful videos that are not alleged to be infringing. Argument number 3, YouTube acted merely as a content hosting platform. Argument number 4, no employee of YouTube is aware of any information that would make any of RT's alleged infringements obvious. Argument number 5, before an alleged repeat infringer can be terminated, they must be adjudicated if they file a counter notification, regardless of whether bad faith is obvious. Argument number 6, Business Casual consented to YouTube's terms of service, thus granting YouTube a license to exploit Business Casual's videos however YouTube sees fit. Argument number 7, YouTube uses anti-infringement technology to actively and diligently police its platform for copyright infringement, which is the opposite of volitional conduct. Argument number 8, after receiving our takedown notices, YouTube promptly removed each of RT's videos that were alleged to be infringing. And lastly, argument number 9, YouTube only reinstated RT's non-infringing content. My friends, try to keep a straight face as we dismantle these together, starting with the first one, YouTube's 35-strike policy. Many months after RT was reinstated, YouTube unveiled a secret and off-the-books webpage in defense of its decision to reinstate RT. I say secret and off the books because this policy does not actually appear anywhere at youtube.com. Indeed, this page is on Google's website, and even still, it's tucked away in a very hard-to-find place, one that few people, if any, have ever seen before this lawsuit. Under this new policy, RT's channels are not actually channels at all, but rather owners of content or content owners. What does this mean? According to YouTube, it means that the Russian government's channels can receive up to 35 copyright strikes every single year, or 9 strikes every few months, without ever facing termination. Now guys, just think about what YouTube is really asking for here. YouTube is arguing that its version of a reasonably implemented policy is one that permits an infringer to repeatedly infringe another person's copyrights up to 35 times every year and never get classified as a repeat infringer. If this situation weren't so serious, this would be laughable. But it's not funny. This is what YouTube actually argues is a reasonably implemented policy. These people are sick. Who is a repeat infringer if not someone who infringes repeatedly? You don't need to be a lawyer to recognize that a policy that does not call for the termination of those who repeatedly infringe the copyrights of others, in other words, more than once, much less dozens of times, is an unreasonably implemented policy. Period. By the way, hey Google, here's my question. Why stop at 35? Why not make it 1,000 strikes? Heck, why not also require rights holders to climb Mount Everest before being eligible to file a takedown request? I'm serious. I'd argue that climbing Mount Everest is faster and less expensive than adjudicating an obvious repeat infringer like RT. Just do the math. The average Sherpa will run you $70,000 to take you from base camp to summit. The journey will take you approximately 2 months. Now consider the fact that I've already spent several times that amount in my case against RT alone and have been involved in this litigation for well over a year. Guys, terminating the account of an obvious repeat infringer should not be harder and more expensive than climbing Mount Everest. This 35-strike policy is proof that YouTube does not equally apply its policies to all channels on its platform. And just as a matter of common sense, a policy that is unequally implemented is unreasonably implemented. So that's YouTube's first argument. YouTube's second argument is that it should not have to terminate the accounts of any repeat infringer. Why? Well, according to YouTube, that would be at odds with the First Amendment because this would entail having to remove lots of perfectly lawful videos that are not alleged to be infringing. But that argument is just, and excuse my language here, misbegotten. If you don't believe that this is YouTube's position, allow me just 60 seconds to play the tape.
What plaintiff wants is an order commending YouTube to ban non-infringing, lawful content from its platform, which is barred by the First Amendment. There's no basis, certainly under the Copyright Act, for the court to order a private platform to remove non-infringing content. Business Casual is claiming that the DMCA somehow requires us to remove not just the 3 infringing videos that they are complaining about, but all thousands and thousands of hours of lawful, non-infringing content that has nothing to do with this case.
If you read these quotes enough times, you can actually begin to taste YouTube's salty animosity for the copyright laws of our country. It is palpable. Mr. Molek, our only gripe is that YouTube does not apply its rules equally. Also, for what it's worth, YouTube is required to take down RT's non-infringing content because that's what happens when your account gets terminated. That's the law. As for the shutdown of RT's associated channels, we're not asking for anything more than what YouTube's own policy requires under the circumstances. This has nothing to do with the First Amendment. By the way, since when did the DMCA start requiring judges to consider ratios of infringing material hosted on a repeat infringer's account relative to the amount of non-infringing material? Oh wait, the DMCA doesn't require any such nonsense. If a person infringes another person's copyrights repeatedly, but also has lots of non-infringing content on their channel as well, that is of zero consideration for a court to consider. Also, and I just have to point this out, I love how YouTube calls attention to RT's views and subscribers. Like, what does that have to do with anything? In my view, it just further underscores YouTube's reluctance to shut down larger channels that make more money for YouTube. I don't want to beat a dead horse here, but I'll just mention one final thing on this topic. The DMCA does not prescribe the penalty of strongly worded warnings for repeat infringers, nor does it prescribe suspensions or copyright school or worldwide video blockings. The DMCA prescribes termination. Is it really a coincidence that the phrase repeat infringer policy is literally an acronym for RIP, rest in peace? By the way, this is not just my interpretation of the law. If you study the legislative history of the DMCA, and I have, what you'll find is that Congress was acutely aware of the fact that the termination of a repeat infringer's account would entail the removal of both infringing and non-infringing material. In fact, it is because of this, not in spite of this, for why the word termination was specifically chosen by Congress. Lawmakers knew that merely taking down a pirate's infringing material would be like playing a game of whack-a-mole. Taking down the pirate's illegal content is not enough of a penalty to stop the pirate from doing it again. Why does YouTube take issue with the termination of an entire account? Because it hurts their business. So that's YouTube's second argument. It is, if I may say, dubious at best. YouTube's third argument is that YouTube is nothing more than a content hosting platform. If only that were true. Here's the way I see it. If YouTube wants to be treated as a content hosting platform in the eyes of the law, then it needs to start acting like one. But it hasn't been. In fact, as you've seen time and time again, YouTube has been doing just the opposite for over a year. By reaching out to business casual as a mediator on behalf of the copyright pirate to try to resolve the pirate's 3 strikes, YouTube has not only proven its actual knowledge concerning RT's years of infringing our copyrights, but in fact, YouTube has morphed. Legally speaking, YouTube has morphed from a passive provider of a space in which infringing activities happen, in other words, just a platform, to an active participant. What does this mean exactly? It means that YouTube cannot just unsee RT's years of obviously infringing activities. It must take action. Case law is also crystal clear about this. In the Second Circuit, the controlling precedent is EMI versus MP3 Tunes, a case that YouTube despises. Why does YouTube hate this case? Because in that case, the court held that if the facts actually known by employee of the service provider make infringement obvious, the service provider cannot escape liability through the mechanism of the safe harbor. Furthermore, the hypothetical reasonable person to whom infringement must be obvious is an ordinary person, not endowed with specialized knowledge or expertise concerning music or the laws of copyright. Little wonder why YouTube has never addressed any emails from its Moscow office, or any other of its executives' emails for that matter. Apparently, YouTube's lawyers think that they could just ignore these emails, and that by doing so they go away. They do not. As for YouTube's fourth argument, YouTube argues that a repeat infringer needs to be adjudicated if they dispute their status as a repeat infringer, regardless of whether bad faith is obvious. But the law does not require adjudication. In fact, this case is the poster child example for why Congress specifically chose not to require the adjudication of repeat infringers when it enacted the DMCA. When you think about it, what YouTube is basically saying is that we don't agree with how the law should be worded. So rather than follow the law, we're just going to go ahead and enact our own version, one that requires repeat infringers to first be held liable in court. By adding the single word to the statute, YouTube has effectively erected an artificial legal hurdle that imposes requirements on rights holders far above and beyond what the law actually requires. This is ridiculous. And I'm not alone in believing this. The Honorable Judge Koeltl agrees with me. The legislative history of the repeat infringer provision supports this conclusion. Both the House Commerce and Senate Judiciary Committee reports explained that those who repeatedly or flagrantly abuse their access to the internet through disrespect for the intellectual property rights of others should know that there is a realistic threat of losing that access. The passage does not suggest that they should risk losing internet access only once they have been sued in court and found liable for multiple instances of infringement. Guys, in cases like this, where YouTube has already acknowledged that the pirate has admitted to filing false DMCA clarifications to avoid the termination of their accounts, YouTube has to step in. YouTube cannot just punt these issues to the court and say, we don't know who's right. Of course YouTube knows who's right. They just don't want to tell the truth. YouTube's adjudication policy needs to be abolished and its attorneys admonished. As for YouTube's fifth argument, YouTube claims that it knows nothing about RT-specific infringements. Their filings even suggest that YouTube doesn't have the specific links to the infringing videos in question. I have several hundred pages of screenshots that beg to differ, so good luck with that one. YouTube's sixth argument is that Business Casual agreed to YouTube's terms of service. Thus, YouTube is immune to its federally prescribed DMCA obligations. But that argument is just fundamentally flawed. This lawsuit has nothing to do with YouTube's terms of service. Read our complaint and you'll see that we did not bring a claim against YouTube for breach of contract. We could have, but we chose not to, mainly because that would have required us to sue YouTube in California. Don't get me wrong, YouTube's terms of service is unconscionable on its face. YouTube cannot just provide pirates with a license to use our content and then keep all the revenue for itself and the pirates. That's not sub-licensing, that's theft. Also, since when did YouTube's sub-license agreement start extending to unlawful content? I don't know about you, but I did not sign up for YouTube to see our videos on Russia's state-owned channels. This idea that YouTube could just excuse itself from liability by granting its own company a get-out-of-jail-free card when it gets caught red-handed is an abomination. YouTube's seventh argument is that YouTube is actually the good guy in this lawsuit because it uses anti-infringement technology, which is evidence that it quote-unquote actively and diligently polices its platform for copyright infringement. But that is grossly misleading. The issue in this case is not that YouTube lacks anti-infringement technology. That has never been our allegation. Rather, what is at issue in this case is that when YouTube learned about an obvious bad actor circumventing this anti-infringement technology, YouTube made the choice to look the other way. There's no genuine dispute that if the infringer in this case was any other than the Russian government, their account would have been terminated. YouTube's terms of service explicitly prohibits the circumvention of YouTube's security-related features. But because the pirate in this case is the Kremlin, they get special treatment. Essentially, YouTube's Orwellian argument is that all channels are equal, but some channels are just more equal than others. YouTube's eighth argument is that YouTube promptly removed RT's infringing videos and therefore cannot be held liable. But that is false, and YouTube knows it. Then again, when has that ever stopped YouTube? For context, the law requires that YouTube expeditiously remove or disable access to content that is alleged to be infringing after receiving a valid takedown request. If YouTube fails to do this, it can be held liable. Now, YouTube likes to talk about the fact that it removed RT's 3 infringing videos, and that this is not in dispute, but that is only half true. And in my book, a half-truth is the same thing as a damn lie. Yes, YouTube did remove RT's 3 infringing videos, but not expeditiously nor easily. As a reminder, I had to send hundreds of pages worth of letters and emails to so many people at YouTube just to remove this infringing content. Pulling down these videos was like pulling teeth. Also, for the record, only one of RT's infringing videos was removed relatively quickly, contrary to YouTube's facts. Waiting 3 days may be considered expeditious by some judges, but that is certainly not true for RT's other infringing videos. Consider RT's infringing Rockefeller video. For this video, YouTube waited nearly a month before taking any action. Why did YouTube wait so long? I believe it's because YouTube conspired with RT as part of a deliberate effort to try to help the Russian government avoid the termination of its 39 accounts. By intentionally stalling on the removal of RT's infringing Rockefeller video, YouTube was trying to help RT avoid receiving a third strike from Business Casual within 90 days. This allegation is supported by several pieces of evidence, including YouTube's own admission to the court that YouTube intentionally waited to remove RT's infringing content. This was not some unintentional delay. YouTube confirmed this. In a conference call with Judge Ramos, YouTube's lawyer explained that the reason why YouTube waited 24 days was because YouTube was concerned Business Casual wasn't considering fair use.
But the reason why YouTube took some additional time for those videos is because the total amount of content in those 2 videos was 10 seconds. 10 seconds of allegedly infringing content, which raises serious concerns as to whether that alleged infringement is actually a fair use. And as the correspondence attached to complaint shows, the reason that YouTube did not remove the content immediately, or within 24 or 72 hours, is because YouTube was concerned the plaintiff was not taking principles of fair use into account. And by the way, fair use is important here because not only was the content so de minimis, 10 seconds, but the content at issue is really historical public domain images. The only originality that they claim is the way that those images were displayed.
This was a major slip-up for YouTube. YouTube's statement to the court is directly at odds with its own help center.
YouTube does not decide what is fair use and what isn't. Only the court can do that. Courts have rejected fair use arguments for songs that only sample a few seconds of someone else's work. So if you're using any amount of content that you don't own, even a few seconds, you're taking a risk of receiving a claim or a takedown.
If YouTube routinely takes down videos for using just a few seconds of copyrighted material, like its help center states, then why would YouTube be very concerned about whether business casual was considering fair use? There's only one rational explanation for this. YouTube was trying to slow down the application of RT's third strike. In short, YouTube statements raise more questions than they answer. As for YouTube's ninth and final argument, YouTube claims that it only reinstated RT's non-infringing content. But just like every other word out of their mouth, YouTube's lawyers are once again just not being straight with the court. YouTube absolutely reinstated other infringing videos that were published by RT. In fact, YouTube enabled RT's later cover-up operation. Not more than 48 hours after receiving 3 strikes, RT quietly began removing videos from its channel with over 138 million views. How do we know this? Because we looked at their social blade. The data is publicly available and easily verifiable. RT would later claim that this is not true, that RT never deleted evidence during this lawsuit. Fortunately, we live in a screenshot world. RT thought that it was clever when it began taking down hundreds of its other infringing videos that probably infringed the rights of many other channels, not just business casual. Apparently, they thought that they could just sweep this under the rug, but that's where RT messed up. These geniuses forgot to remove the hundreds of videos that they were trying to hide from us from their still publicly available playlists that were still accessible on the homepage of their channel. How do we know this? Because we have screen recordings. As you can see for yourself, hundreds of videos mysteriously started becoming unavailable immediately after RT received its third strike from business casual. This was a massive cover-up operation undertaken for a singular purpose: to avoid receiving additional strikes. This is also evident by looking at RT Arabic's historical viewership. As you can see, they've never engaged in this kind of activity before. Deleting evidence during an ongoing lawsuit is sanctionable, and make no mistake, YouTube is just as culpable as RT. The day after RT Arabic was reinstated, videos totaling billions of views instantly disappeared. This cover-up operation was directly enabled by YouTube Moscow. If you've made it this far into the video, I'd like to say thank you. I've probably rewritten the script at least 100 times. But I must tell you, this last part has taken me the longest to write. Maybe that's because I just didn't know what to say. Other times I think it's because I knew the words, but I just didn't have the courage to say them. Some of you may be asking, Alex, why did you take so long to make this video? I think about that a lot. There are many reasons. I won't go into all of them. But I will admit this much. I was afraid. I was afraid that this video would serve as a tutorial to copyright pirates, a step-by-step guide on how to avoid the termination of your account. I also didn't want to publish this video because for the longest time, I just could not make peace with the fact that this could be true. How could YouTube, an American company, collude with Russia? Why did YouTube make the decision to side with an obvious copyright pirate backed by the Kremlin over its own community of creators, the very people who make YouTube possible? As someone who's been making videos for over a decade, this was unreconcilable to me. YouTube is a company run by cold, hard pragmatists. YouTube knows that its reputation is worth far more than whatever money it makes from the Russian market, and most certainly RT's channels. So then why? Why did YouTube make this calculated decision to gamble its reputation? For over a year, I wrestled with this question. I now believe the answer is twofold. First and foremost, YouTube knows that it doesn't have any real competition. As a video creator, YouTube is the only shop in town. There is nowhere else to go online. And so, from YouTube's perspective, it's less concerned with the negative optics of colluding with the Kremlin. You don't have to fear losing your content creators when you have no competitor to lose your content creators to. So that's the first reason. I also believe that a big part of why Google has acted so willfully un-American is because Google is not an American company. Alphabet's board inherently believes that merely having your company incorporated in this country makes it American. It does not. An American company stands for American values, but Google doesn't. If you need verification of this, look no further than Alphabet's own investor relations page. Read the fine print, and you'll see that Google tells its investors that it is committed to advancing freedom of expression globally. And yet, despite this, YouTube routinely takes down videos from Russian citizens who merely criticize Vladimir Putin. In the eyes of the Kremlin, anything that is viewed as disrespect toward the state or the president is flagged as terrorism. But that is, of course, nonsense. Watch these videos, and you'll see that the only thing that these innocent Russians are asking for is a better life. One where they can take to the street and voice their opinions without getting beaten and whisked away into a dark cell. YouTube promptly removes this kind of pro-democracy content at the Russian government's behest, and they do it routinely. How often? About 92% of the time, and that's according to YouTube's own numbers. This is unacceptable, and it has gone on for too long. Rather than take a stand against this blatant authoritarianism by simply allowing this content to stay up, YouTube has instead chosen to be totally complicit. If YouTube was actually an American company, it would not comply with these censorship orders. These people don't know the first thing about what it means to be an American. But I digress. Tell me how you really feel. By making these legal arguments, which are now public record, Google has forever cemented its legacy as a Kremlin colluder. Susan Wojcicki, there is no hiding from this. This is a scandal. Your lies have been exposed. And that brings me now to the final part of this video, Judge Koeltl's opinion and the current state of our cases. Let me start with our lawsuit against Russia. Since bringing this case, RT has hired an army of lawyers, including 3 separate law firms, just to defend against our suit. And I'm happy to let you know that Russia's efforts to throw out our case have been completely unsuccessful. As of a couple months ago, Business Casual successfully defeated RT's motion to dismiss on all 3 counts of copyright infringement. Basically, Judge Koeltl has said, Russia, you guys are out of your mind, your use was not fair, and I am not dismissing this case. This is a huge win for Business Casual. The significance of this decision cannot be overstated. Within a few months, RT will be an adjudicated repeat infringer. So that's the end of that, right? In the end. Remember how YouTube said earlier, we don't know who's right, and therefore Business Casual first needs to go out and prove its case against RT, and then come back to YouTube once that's done? Well, YouTube said that about a year ago, and now here we are. Very soon, RT will be an adjudicated repeat infringer. We will have proven our case. And yet, despite this, YouTube is still refusing to acknowledge before the court whether YouTube will shut down RT's channels if RT files an appeal. This is madness. YouTube is essentially saying that the only way to ever remove a repeat infringer from its website is to file a lawsuit, win at the district court, win again at the appellate court, and then win one more time at the Supreme Court. Only by going to the highest court in America, which only hears about 60 cases a year, will YouTube consider the matter fully resolved. This is what YouTube argues is a reasonably implemented policy, or at least they've never denied that this is their policy. In my opinion, this is totally unreasonable. But of course, my opinion really doesn't matter. The only opinion that matters is the opinion of the court. And that brings me now to the toughest part of this video. Despite everything that you've just heard over the past hour and a half, the court has decided to dismiss our entire lawsuit against YouTube. Every single one of our claims has been thrown out. YouTube's arguments that I read earlier were not just arguments, they were excerpts from the court's opinion granting YouTube's motion to dismiss. If you guys are wondering how this possibly could have happened and how a judge can get it so wrong, it's because YouTube's lawyers are pathological liars. These people have no regard for the truth. Put simply, YouTube has been successful in misleading the court. It really makes one wonder just how much bad case law is out there. How many other cases have been incorrectly dismissed? Anyway, all of this is to say that our battle is just beginning. We are not going to give up. YouTube may have won this battle at the district court, but mark my words, we will appeal this decision. Susan Wojcicki, listen closely. You will be deposed. We will fight again at the appellate courts, and if necessary, I will take this all the way to the Supreme Court. Business Casual will win this war. I will never stop. I will appeal and appeal and appeal until justice is inevitably served. Evil will not prevail. YouTube knows that what it is doing is wrong, but they continue to do it anyway. And in my book, that is the definition of evil. It is time that we put a stop to this insanity. If you are a fellow YouTuber and you are tired of YouTube turning a blind eye to obvious pirates who steal your videos, then I ask that you join me and take a stand against YouTube with me. This case is our opportunity to finally say to YouTube, no, you cannot just turn a blind eye to obvious repeat infringers. No, YouTube, you cannot just invent a new 35 strike policy for the Russian government when you get caught red-handed not enforcing your 3-strike policy. No, you think that you can just betray the entire YouTube community? Fuck you. And do you honestly think that you can get away with lying to a federal judge because you're not under oath? No, you cannot. You think that you can collude with Russia? Niet! Y'all have crossed the line. And it is time that we send them a message. My friends, if you want to help, we have a couple ways that you can get involved, and not just financially. First, please share this video with everyone that you know, friends, coworkers, family members, and most especially, fellow YouTube creators. YouTube will almost certainly censor this video. Probably not by taking it down outright, because that would be too obvious, but rather by shadow banning the video so that it basically does not appear anywhere in the search results or alongside other videos. Emailing this video to other creators, texting it, and using non-Google services to directly send this video, it's the best way to get the word out. But just in case YouTube does take down this video, it's also available on Vimeo and Rumble. To help get the word out, we also have posters with QR codes linking to this video. Please, feel free to print them and plaster them everywhere in your city to help get the word out. The link is in the description below. Second, if you are a YouTuber and have dealt with a copyright pirate like RT who submits counter notifications in bad faith to avoid the termination of their account, please send us an email at repeatinfringers@protonmail.com. We want to hear from you. Tell us your story. We are collecting evidence and continuing to build our case, which gets stronger every day. Third, if you are a YouTube employee and you are tired of YouTube's collusion with Russia, as well as other unethical and disturbing internal activity, then you can make a difference by confidentially becoming one of our brave insiders. If you have any tips, and especially anything related to Google Moscow, please send us an email at ytwhistleblower@protonmail.com. Ladies and gentlemen, I opened this video with my favorite quote from Albert Einstein, and I'd like to leave it with you now. The world will not be destroyed by those who do evil, but by those who watch them and do nothing. And so with that, I end this video with just 3 words for YouTube and all of its lawyers. Bring it on.